Welcome back to this third segment of Law Sessions Contract Law Remedies. And before the break, we were considering the damages element, and certainly we were looking at the extent to which your loss or your damages rather would be limited. Now, we will start off by considering a duty to mitigate loss. Now, let me just, before I go into duty to mitigate loss, I know that at various points I keep referring to tort, but let me make clear that together, tort and contract are known as the common law of obligations. And as such, when you look at contract looks at a situation where there's a relationship between two people, which between them they've agreed it, whereas when you look at tort, you're looking at a relationship between two people where the law has imposed the obligations. So I do draw parallel, but please do not let that throw you at all. Rather, you should pick up on that to be able to use it in your answers or use it to explain a particular situation, because something might occur in tort which may be similar or different in contract. And that is the only reason I use it, is so that the other type of situation in respect to the law of obligations, you look at drawing a parallel. Okay, so going back to a duty to mitigate loss, the claimant, of course, whether it be a contract or tort, a claimant is not allowed to just sit back and allow his losses to mount up and just think, well, I've won the lottery now, I'm just going to let everything be able to be claimed from the defendant. The claimant is under a duty to take reasonable steps to reduce his loss. Reasonable steps. He doesn't have to, go overboard, but at the same time, he can't just sit back and let the losses accrue willy-nilly. In the case of Payzu, Payzu, and Saunders in 1919, the terms of the contract there was that the defendant was to deliver goods to the claimant on a monthly basis, and the claimant was to pay for the goods within 1 month of it being delivered. Now, the contract was to run for 9 months. The claimant received the goods at a discounted price because he had committed to purchase from the supplier over the 9-month period. The claimant was late in making the first installment. This, of course, amounted to a breach of warranty, not entitling the defendant to repudiate the contract. Just so you know. Now, the defendant refused to continue with the original contract, but told the claimant that he would deliver the goods in future if the claimant paid cash on delivery, and would still let him have the goods at the discounted price. Now, the claimant rejected this offer and purchased the goods elsewhere at a higher price. He then sued the defendant, claiming the difference between the contractually agreed price and what he actually paid for them. Now, I think you have a fair idea of what the court is going to say about that. The court held that the claimant was not entitled to the damages, quite rightly, because it can't be that he was late in paying, and then when the other party refused to extend him the terms, he said, fine, well, I won't bother, I'll go somewhere else, and then what I'll do is they'll charge me more, I'm going to sue you and you pay me the difference. Court said no. The court said he was given the opportunity to purchase at the discounted price, but rejected this. He was under a duty to take reasonable steps to mitigate his loss. The offer was a reasonable one, and one which the claimant could easily have complied with. Now, I want you to also consider Pilkington and Wood, case that we considered earlier, for a second example of that principle, and I would suggest that you look at that. Now then, what can you recover for? What are the quote-unquote heads of damages? Well, looking at some of the various heads of damages under which an amount can be claimed to reflect the different types of loss, well, we flagged up earlier that these would of course include your loss of bargain, your reliance loss, but we see some cases awarding for discomfort or disappointment. We have even seen inconvenience, diminution of future prospects, and and we have seen some degree of speculative damages, and of course we will touch on liquidated damages clause as well. So there has been a wide cross section, some of course more prevalent than others. If we start with the main head of damage, of course, you're looking at the loss of bargain. As I say, we touched on that before. This is your expectation loss, and it is all about what the parties had bargained for. If it is that I say to you that I am ordering a quantity of Christmas trees to be delivered to me by November 1st, it's Christmas trees. They can only be for Christmas. So if you turn up with them on January 1st, it's not going to help me very much, because the fact of the matter is that I would have sold them on the run up to Christmas. So I would then look at what you would have charged me for them. Let's say 10 at £10 each, and I was going to sell them back at, say, £50 each. I would now look at what I would have lost, which would have been the profit of £40 times 10, of course. So I could then sue you for my expectation loss. Now, reliance loss, again, we touched on that earlier, and I said to you I would get back to the Anglia Television and Reed case. In Anglia Television and Reed, which is a 1971 case, the claimant, who were Anglia Television, had engaged an actor, Oliver Reed, to play the leading role in a television play. Now, after the parties had contracted, Reed pulled out and Anglia was unable to find a replacement. They, of course, had to abandon the play, but they had certainly incurred expenses totaling somewhere in the order of nearly £3,000. The court said that while damages generally seek to put the parties in the position they would have been had the contract been performed, the parties had elected to claim reliance loss and to recover the expenses incurred in this abortive transaction. And as such, the courts allowed Anglia to recover their expenses from the defendant, which is pretty fair. They had spent monies in order to put the play on. Had they, for example, gone for expectation loss, they would be seeking to recover what it is they would have gotten had the play been done. But again, sometimes that sort of calculation is difficult. You know, you see a movie come out, it bombs, it loses money. Play could come out, no money is made. So, of course, difficult. So, as far as they were concerned, just give us back our money that we've expended before you pulled out. He didn't want to. The courts agreed with them. What about discomfort and disappointment? Well, the general rule had never been insofar as recovery for that. But we've seen the cases taking a slightly different turn. Now, if we look at the case of Jarvis and Swan Tours in 1972, this was a Court of Appeal case in which Mr. Jarvis had booked a 15-day skiing holiday over Christmas with Swan Tours. Now, the brochure in which the holiday was advertised had made several claims about the provision of enjoyment relating to house parties, a friendly welcome from English-speaking hotel owners, a variety of ski runs, afternoon tea and cakes, and a yodeler evening. Well, many of these either did not go ahead or were not as described. So Mr. Jarvis felt hard done by, and he brought a claim for breach of contract based on the disappointment. Now, the trial judge awarded him approximately £30 damages on the basis that he had only been provided with half of what he had paid for, and said that no damages could be recovered for disappointment. Well, he appealed. The Court of Appeal said that where a contract is entered for the specific purpose of providing enjoyment or entertainment, damages may be awarded for the disappointment, distress, upset, and frustration caused by a breach of contract, failing to provide the enjoyment and entertainment as promised. So that is why the British tend to take their holidays so very seriously. Second case, of course, was considered holiday scenarios, of course, is Jackson Horizon Holidays. Now, Jackson Horizon Holidays, 1975 case, which also can be considered in the context of privity of contract. also a case that came before the Court of Appeal, and in that Mr. Jackson had booked a 28-day holiday in Ceylon for himself and his family through Horizon Holidays. The hotel turned out to be unsatisfactory for various reasons. It was dirty, no services provided. The trial judge, so the judge at first instance, made an award for the disappointment suffered by Mr. Jackson, but the first instance judge said that it was certainly outside his powers to take into account the disappointment which was suffered by his wife and his children, since they were not party to the contract. Now, the point here, of course, is Mr. Jackson is the one who bought and paid for the holiday, but clearly it was not him alone who was going on the holiday. But the judge took it from a literal standpoint of the contract was made with him for the benefit of his family. Now, of course, having looked at the privity of contract law session, you will know, of course, that when you look at the contract right of third parties, that now the family would certainly be held, but we're looking at mid-1970s here. Mr. Jackson, of course, appealed, and the court said that Mr. Jackson was able to recover for the disappointment suffered by his wife and his children. The court said that this sort of situation amounts to an exception to the rule of privity of contract based on the decision in Bezig and Bezig. Now, as I said earlier, the parties may stipulate that a certain sum must be paid on a breach of contract. Now, we move here into the area of liquidated damages. Now, as I also said, if the sum is a true picture of an estimate predetermined by the parties, it will, of course, be enforced by the courts, as the courts will be able to say that this is liquidated damages. But if the sum is not a genuine sum, if the sum is an inflated figure which is there to some way or other place a kind of duress situation on the other party, then it is a penalty. The courts will not enforce it. When I flagged this up earlier, I told you we would come back to Dunlop Pneumatic. Now, in Dunlop Pneumatic Tire Company and New Garage Motor Company, the claimant there was Dunlop. Dunlop manufactured tires and distributed them to retailers for resale. Now, the contract between Dunlop and New Garage contained a clause which prevented New Garage from selling the tires below list price. In the event that they were in breach, the contract said that 5 shillings would be payable for each tire sold below the list price. The defendant sold some tires below the list price, and the claimant brought an action for damages based on the amount specified in the contract. The defendant argued that the clause was a penalty clause and therefore unenforceable. The trial judge said it was a liquidated damages clause and awarded the claimant 5 shillings per tire. The Court of Appeal reversed this, of course, and said the clause was a penalty clause and awarded the claimant 2 shillings per tire, representing the actual loss suffered. Claimant appealed to the House of Lords. The House of Lords says that the clause was a liquidated damages clause, not a penalty clause. Now, Lord Dunedin set out the difference between a liquidated damages clause and a penalty clause. And he said, 1. Though the parties to a contract who use the words penalty or liquidated damages may prima facie be supposed to mean what they say, yet the expression used is not conclusive. The court must find out whether the payment stipulated is in truth a penalty or liquidated damages. This doctrine may be said to be found in nearly every case. He said the essence of a penalty is a payment of money stipulated as in terrorem of the offending party. The essence of liquidated damages is a genuine, covenanted pre-estimate of damage, and he quotes, of course, Clydesdale Bank. He makes a third point to say the question whether a sum stipulated is penalty or liquidated damages is a question of construction to be decided upon the terms and inherent circumstances of each particular contract, and it must be judged as at the time of the making of the contract and not at the time of breach. He goes on further to say, in order to assist in the task of construction, there are various tests which have been suggested, which, if they apply to the case under consideration, may prove helpful or even conclusive. And he says these would include, for example, he said, it will be held to be a penalty if the sum stipulated is extravagant and unconscionable in an amount which, when you compare it to what is being contracted, it is far higher. Again, he said it will be held to be a penalty if the breach consists only in not paying a sum of money and the sum stipulated is a sum greater than the sum which ought to have been paid. So he looks at it from a point of view of, if it is that a sum of money is going to be paid which is pretty unconscionable, it is unlikely to be a liquidated damages clause and more of a penalty clause. Now it says there is a presumption, but no more, that it is a penalty when a single lump sum is made payable by way of compensation on the occurrence of one or more events. So again, as I say, they look at how the clause itself impacts on the party against who it is used. Now, we will consider this a little bit more as we go into the break. We will conclude on it, of course, on that particular area, and then we will conclude on the whole area of damages and remedies in that regard.